Well, thank you, Chairman Davidson and Ranking Member Beatty. I'm John Court. I'm with the Bank Policy Institute. We're a nonpartisan research, policy, and advocacy organization whose members are the 40 largest banking organizations that operate in the U.S. You have my written testimony, so I won't rehearse it, but just instead try to identify in my short time sort of the core problems with the current AML regime, explain how current regulators, in our view, are seeking to address those problems, and then identify two key areas where we think more work needs to be done. The main problems with the current regime, which I think are pretty well documented and widely agreed upon. First, it's just an outdated, inefficient framework. The regime is built on a roughly 45-year-old framework that's been repeatedly expanded, but not fundamentally modernized. As a result, the regime is poorly suited to today's illicit finance and technologies. Second, it's replete with process-heavy supervisory expectations and examiners who tolerate little to no errors on low-risk matters. Banking agency examiners focus heavily on detailed processes and documentation rather than real financial crime risk, fostering a check-the-box culture and forcing banks to waste precious financial crime-fighting resources trying to satisfy examiner demands on immaterial items. Third, it over-deputizes banks with severe penalties, creating radically perverse incentives. Banks are effectively deputized as frontline AML enforcers and face severe penalties for compliance missteps, which encourages defensive over-reporting, conservative de-risking, rather than smarter, true risk-focused approaches. Fourth, it produces too much volume and not enough value for law enforcement. Banks generate massive volumes of alerts, SARs, CTRs, and very few of those filings result in law enforcement follow-up, indicating that the regime emphasizes volume over actionable intelligence and usefulness. Fortunately, there's reason for optimism. Congress set the stage for reform by enacting the AMLA in 2020. Among other things, the legislation would modernize the Bank Secrecy Act framework, create a more effective risk-based, innovation-friendly regime with a mandate that banks allocate resources towards higher risk activities and away from lower risk activities. And now regulators, admittedly after some fits and starts, and 6 years later, have begun an effort that we think faithfully implements the core objectives of the AMLA. They recently issued a proposed AML program rule that reflects a meaningful reorientation of the AML programs towards a more effective risk-based framework that aligns with the AMLA. We're still waiting for the Federal Reserve to approve the proposal, but the other agencies have gotten it out. Regarding the overly prescriptive one-size-fits-all expectations in the current regime, the proposal corrects for this by moving to a principles-based framework that gives banks discretion to design their own programs and is intended to avoid examiner second-guessing of institution-specific risk judgments. Also, whereas the current system does not sufficiently prioritize higher-risk activities, the proposal explicitly directs banks to allocate resources towards higher-risk activities and away from lower-risk activities. And finally, the proposal, and this is significant and important, contains key components designed to encourage banks to utilize technological innovation to combat financial crime. Nevertheless, we think the proposal could be improved in various ways, and we'll be filing a comment letter with the agencies to lay out our views. Mostly, we're going to encourage the incorporation of key concepts from the proposal's preamble into the regulatory text to ensure clear, uniform standards and consistent application by examiners. It'll also make the reforms more durable. We'll also recommend that FinCEN play a much more active role in overseeing how the banking agencies conduct their AML exams to ensure those exams are aligned with the national security and law enforcement priorities of the government. Once the program rule is done, it's important to turn to two other areas of the BSA regime that we think are in critical need of reform. First, modernize the SAR and CTR reporting rules, which are currently fragmented and outdated. This can principally be accomplished in two ways. One, revise the reporting thresholds, as the chairman indicated, to keep pace with inflation. And two, incorporate directly into the SAR CTR regulations various FAQ and guidance documents that have been issued over the years. The second is replace the existing banking agency FFIEC BSA AML exam manual, which is voluminous, with a new one that comports with the final program rule. FinCEN should lead that effort, not the banking agencies. I appreciate the subcommittee inviting me today, and I look forward to answering any questions.
Thank you, Mr. Court.